Employer fucked her.
Literally? Okay.
He's withholding my...
Okay. First things first. Hi, I'm Cody.
I'm Vivian.
Hi, Vivian.
Vinny.
Hi, Vinny. I got to let you know this is being recorded, okay?
Okay.
Okay. How can I help?
So my employer is withholding my income from a sale that I closed.
Okay.
And I just filed against him in a small claims court.
Okay.
But I do still need to call a lawyer.
If you filed a lawsuit and you're already a small claims court, what do you need a lawyer for?
Right? My friend gave me a free lawyer's number if needed. But I shouldn't need that because I have all the evidence.
Okay. What do you have in way of evidence?
Him saying that he's gonna pay me by this month, and then it kept leading to the next month. I was patient with him for a whole month. I gave him another 2 months.
Do you have any kind of an employment agreement or a contract with him that says he'll pay XYZ and the commission structure? Great. That's all you need, right? If you filed the lawsuit and you've had him served, right? Do you have a court date yet?
I just did it
Okay.
just yesterday.
So the way it's going to work is once you file that lawsuit, you need to make sure that you did pay for service, right? So go look at your documents. There'll be a thing at the bottom where it'll ask a question about service, and there'll be a box that'll either say like sheriff's, public, or private, right? And if you checked none of those, that's a problem. If you checked sheriff's and you didn't pay the extra $50 for that, then they're not going to serve him with it. And if you checked private, then they're not going to do anything because they're assuming you're going to have somebody else serve it, right? Someone has to serve a copy of the lawsuit on the person you're suing. If I want to sue Vinny over here, I have to draft a lawsuit, and then I've got to pay someone who's not involved in this to go out and hand Vinny the lawsuit. And until you get the lawsuit, the case doesn't move forward, right? But once you get service, they'll give you a court date. He'll have 30 days to respond, to either accept or deny. If he doesn't respond, right, you'll show up to court and you'll say to the judge, I want a default judgment. And that means you automatically win. If you don't put in an answer and deny the charges against you, it's presumed you're not denying them. If he does show up, then y'all will have a conversation with a judge or maybe some mediation beforehand where you'll lay out your your facts and how you think things went. He'll lay out his, and then a mediator or a judge will make a decision of who he thinks right. And if you're right, you'll get a judgment, and then you can use that judgment to make him pay you.
It's been over a year, so could I get more than what he owes me? Because it's been almost over a year.
So the only thing you're going to get is the amount of funds that are actually owed to you. It's going to be down to the judge and what he wants to award you, right? They're generally speaking, your damages are the money that he's withholding, right? You may be able to ask for some kind of an interest on top of that, right? But that would be judicial interest, which is going to be like, I think it's 7% attached to prime. So if he owes you $100,000 and it took a year, you get an extra $7,000 if they give it to you. But odds are you're not going to get that. What you're going to get is you're going to get an order for the amount of money that is owed to you. And then if he doesn't pay you, you can then go back to court and ask for a garnishment. And then you'll get a separate piece of paper that you can then go to his bank or his employer, and they will take the money from him and give it to you.
Company that I worked under.
Doesn't matter. Okay. Someone's paying him.
Okay.
Somewhere he's getting money, right?
Okay.
So like you can take that to the bank where his business account is. You can take it to wherever he banks. And be like, I have this court order that says he owes me $5,000, and if he's got $5,000, they're going to give it to you.